Welcome back. Let's continue here now. The legal challenge by MK Party to challenge President Cyril Ramaphosa's decision to place the Minister Senzo Mchunu on leave of absence and appoint Professor Firoz Cachalia as acting police minister, and the establishment of the Madlanga Commission has been struck off the urgent roll. We now roped in Ulrich Roux, founder and managing director of Ulrich Roux Associates. Ulrich, a very good afternoon to you, and thank you so much for your time. So what does this all mean in legal terms for the MK Party's challenge to now be struck off the roll for lack of urgency? I mean, is this a case of procedural matters, or does it weaken the substance of their case?
Well, the court did not even entertain the merits of the application for an interdict to halt the commission because the court found that the horse is bolted. Now, what that means is the court cannot grant an order interdicting the commission from proceeding because it has already commenced. It, of course, commenced yesterday, and the application was only heard today. So the matter was struck from the High Court's role because of a lack of urgency in the application. There simply is no urgency, as the court found, because the commission has already commenced, and therefore no relief which the court might grant could even assist the party bringing the application. And that is that. So they did not make any ruling or finding on the merits of the matter. They simply struck the matter from the court before even entertaining that.
Yeah. Could the party's president, Jacob Zuma, and the MK Party itself, they've been saying that this is a conflict of interest because the judiciary cannot be both the accused and the investigator in as far as the commission is concerned. I mean, could the party re-enroll the case on, non-urgent matter? And if so, how might that process unfold, do you think?
Well, I think their chances would be equally slim if they were to choose to do that. The fact of the matter is that the commission is pursuing, it's continuing, and, the evidence that is led during that commission is going to be accepted, for the time being and until a court rules otherwise. President Ramaphosa was fully within his rights in order to order that this commission commences. So I don't think that there would be any chance of success, even if they were to place it on the normal court's roll. Remember that the argument regarding the conflict, pertaining to the judiciary, we have a fully entrenched rule and law in South Africa regarding the separation of powers. Any findings during this commission will not be binding, but it could, of course, lead to further investigation possibly being conducted and further action being taken by the South African Police Services and or the National Prosecuting Authority or the South African Police Services on an internal basis pertaining to possible disciplinary steps being taken. So for the time being...
I didn't catch that. Could you try again?
And I don't think any application would succeed.
I want to just go back to that point that you raised about the court not even hearing this on merit. I mean, how significant is it that the case was never heard on its merit? I mean, does this keep the door open for future constitutional or even administrative kind of challenges?
Well, that is the first hurdle that any applicant before the court needs to overcome when an urgent application is launched, and that is the urgency. Remember that an urgent application does away with all of the normal rules of court pertaining to timeframes and the exchanging of pleadings, the filing of affidavits, etc. So the court must find that it is of such an urgent nature that it needs to be heard immediately and urgently, and if it is not, then justice will not be seen to be done. So that is the hurdle that they could not overcome, and the reason, quite simply, that the court furnished was, how do you expect us to stop something which has already started? You want us to order an interdict preventing this commission from ensuing and from carrying on, but it has already started, so we cannot stop it. And that is basically what the court said, that they did not overcome that urgency hurdle. Had they launched the application last week, prior to the commission starting and commencing, it might have been a different story. But unfortunately for the MKP and their legal representatives, that was not the case. And being in court today, a day after the commission started, was simply too late.
Ulrich, thank you so much for your time. Really do appreciate it. Ulrich Roux, founder and managing director of Ulrich Roux Associates.